3 or a couple of minutes past 6 by my watch, so we've got a lot to get through this hour. So I think we'll crack on. Hopefully everyone can hear me loud and clear. So hello and welcome to our third Crammer. Well, it's James again, and I am again your presenter. And welcome back to those who have previously been with us, and a warm welcome to those joining for the first time. So what have we done in the first couple of Crammers? Well, the first one, you remember all that way back, we looked at question types and case law. We looked at various things like kidnap and burglary. And then in our second Crammer, we covered mens rea, actus reus, entry, search and seizure, and a look at detention of persons in custody. I think even if my memory serves me back, didn't we even have a look at a little bit of Latin for the Latin term of intervening acts? Does everyone remember that? Novus actus interveniens. Don't worry, you're not going to be examined on that, but just shows you how fantastic you were that we were picking up a bit of Latin as well in that second session. Right, well, today's session is once again brought to you by Police Revision and Red Snapper Learning. Police Revision has helped over 17,000 officers preparing for their exams, and a one-off subscription gives you access to hours of video presentations, questions and mock examinations, as well as a separate Crammer course. And I'll go through a little bit more at the end, but with code UKCH25, you get 25% off, which takes it down to a total subscription of around £75. But that's enough of the advert. Right on with the session. So today's session is really good. It's all about serious crime. We can put the codes of practice away today and we can focus on murder, drugs, riots, and all of those interesting topics that you joined the police to investigate. So what are we going to look at today? Well, I'm hoping to get through common assault all the way up to murder, and that's all of the assault offences. We'll have a good look at public order and injunctions, and then we'll have a look at misuse of drugs. So about 4 or 5 topics there, big topics, which we're going to focus on today. We only have an hour, so we're really going to look at our learning and see how much we can get out of it. So we're going to follow the same pattern as we have for the last few Crammers. We are going to mix in a good few exam style questions, which once again, feel free to pop your answers on the chat, all of those correct answers. You were so good at the last 2 Crammers. And then if there are any questions, what I would say is either pop them on the chat or just wait for me at the end, or I'll give you an email address and we can communicate. I've spoken with you, a couple of you, over the last few weeks, and I'm more than happy to cover them off at the end or speak to you separately. Right, well, I think because of the amount we've got to go through today, let's just crack on with the session. So we'll start in our Crammer by looking at serious crime, specifically the journey from low-level assault leading right up to homicide. And it's a really fascinating topic, and as investigators, some of the most interesting cases you're going to deal with, or you do deal with, are around assaults. So let's, as per normal, let's put the onus on you and let's kick off with a question. So as per the exam, you've got 90 seconds to answer this question. I'll just go through with it now. Once you've had a read, you've had a chance to answer your question, pop the letter or the answer you think on the screen and we'll go through it. So Terry and Jennifer went out on 2 dates after meeting on a dating app. Terry thinks it's going well, but Jennifer does not think there is a spark there and thinks Terry is a little strange in his manners. Jennifer texts Terry thanking him for the 2 dates, but suggests they see other people. Terry is furious and wants to seek revenge against Jennifer. He waits 2 weeks, then makes 30 phone calls to her, staying silent each time he calls. Jennifer, who lives alone, is terrified and suffers psychiatric harm owing to the phone calls. Which of the following statements is correct? A. Terry does not commit the offence, he's staying silent on the phone calls, and an assault cannot be committed in this manner. Terry should be charged with common assault, section 39 offence, as this is the highest level of assault that can be charged with, owing to the fact that he has stayed silent. Terry can be charged with a section 47 offence, ABH, as he has caused psychiatric harm to Jennifer. Or D, psychiatric harm through the making of phone calls is considered an extremely serious offence and charging should start at section 20 GBH level, although expert evidence will be required to show the level of harm suffered by Jennifer. So whenever you're ready, over to you. Pop your answer on the screen. I'll give you a few seconds and then we'll go through it on the next screen. Now, it's no fun playing with you lot at the moment, is it? Because every question we start off with, they're far too easy and you're fantastic. And as you can see, everyone putting on the screen now has gone for C. And of course, the answer is C. Terry can be charged with Section 47 ABH as he has caused psychiatric harm to Jennifer. Absolutely fantastic, guys, as normal, as expected. As I said, I should have brought the exam forward. So to answer this question, you must have knowledge of the case of RV Island, 1998. In this case, the defendant consistently called 3 separate women over the course of 3 months. During each call, he did not speak, but instead breathed heavily on the line. He was prosecuted and convicted for assault occasioning actual bodily harm on the grounds of the psychiatric injuries suffered by the victims. The defendant appealed his conviction and argued that silence cannot amount to assault, and further that psychiatric harm was not actual bodily harm. Well, the issue in this was whether silence could amount to ABH and whether psychiatric injury can amount to ABH under the same provision. Well, to quote Lord Steyn, the proposition that words cannot suffice is unrealistic and indefensible. The phone caller intends his silence to cause fear and intimidation. In simple terms, as you all wonderfully said, Terry committed Section 47 with his silent phone calls. But that was really just a lead-in. It's really important to understand the concept of assault before we look at further specific offences. So, well, what is an assault? Well, an assault is defined in the case of Fagan versus the Metropolitan Police Commissioner in 1969 that outlined an assault is any act which intentionally or recklessly causes another person to apprehend immediate unlawful violence. There are a lot of key words in that definition, so as we like to do on police revision, let's simplify it. Well, we know from our question that a physical assault is not always required to satisfy the offence. But there are 2 elements that are key: the intention or recklessness of the offender and the apprehension of the victim. Therefore, if John says to Mark, "I'm going to smash your face in," and John's intention is for Mark to believe the threat, and Mark does believe it, you have an assault. Now, this is a key part for the exam and exam questions. Mark only needs to believe the assault is going to take place. He doesn't need to fear it. And it's really important that we get those little nuances on here, because if you're posed with a question where it's about fearing it and not believing it, then of course it's their answer. Always remember that. Mark only needs to believe the assault is going to take place. He doesn't need to be frightened of it. Well, what about the phrase immediate unlawful violence? Well, so the term immediate is somewhat subjective, and it has been found in cases that this can be as long as 1 or 2 minutes in the future. However, the longer the gap, the less likely it will be classified as immediate. Now, unlawful violence is self-explanatory. Using our example of the threat by John, "I'm going to smash your face in," means that he's threatening to punch Mark in the face numerous times. Well, what about if the threat and assault is conditional? Well, unsurprisingly, this depends on the circumstances and the likelihood of it occurring. For instance, if John says to Mark, "If it wasn't for this large metal fence, I would smash you up." Well, if there was absolutely no way of John getting through or around the fence, well, the threat is hypothetical. But if there is a limited or no blocker, and instead John says to Mark opposite him in a pub, "When I finish my pint, I'm going to smash your face in," well, the threat is very real. Right, so we've looked at the concepts of assault, and now let's start having a look at some specific offences. Okay, on the screen, you can see the first of 2 tables where we're going to look at the wording of the offence and then any key point or exam points that will be of benefit for you. So let's start with Section 39 common assault. This we know is the lowest level of assault, which is little or no injury, and it can include reddening, scratches, minor bruising. Now, it's important to note that the racially or religiously aggravated common assault can be tried on indictment on its own, so seriously increases the severity. Section 47, assault occasioning ABH, is our next level up, but it's our next level up only on the degree of injury or harm to the victim. Case law has once again dictated our understanding of the terms actual bodily harm, or ABH, which is essentially hurt that is more than transient or trifling. And we're going to come across those two words, transient and trifling, a little bit in the future. But as we saw from our question, this of course can include psychological harm. But something I didn't mention in the question from there was if prosecuting psychological harm and it is not admitted by the defendant, then expert evidence must be called by the prosecution. Interestingly also, that case law outlines that the substantial cutting of someone's hair could qualify as a Section 47 assault, and that case dealt with the cutting off of a ponytail, so it was quite substantial. Let's move our next level up. GBH Section 20, the wording of which is, whosoever shall unlawfully and maliciously wound or inflict any grievous bodily harm upon any other person, either with or without any weapon or instrument, shall be guilty of a misdemeanor. Well, let's pick out some key words from Section 20. Let's start with the word maliciously. Well, maliciously means that the defendant must realise that there is a risk of some form of harm that is going to befall the victim, even if they didn't quite foresee the high level of harm that was going to be caused. So let's go back to John and Mark. John throws a stone at Mark's face, intending to give him a nasty cut. Instead, hits his eye with the stone and blinds him. Well, John intended to hurt Mark, but did not expect to hurt him to that extent. So what do we understand of the word wound? Well, a wound is a high level of injury which includes the breaking or cutting through all layers of skin, realistically such as somebody being stabbed. But an interesting bit of case law, you know I love my case law, just those questions are just born from it from here, is the case of RV Birmingham 2002. And this case outlined that a large number of minor wounds, so those wounds that didn't cut through all layers of the skin, but there was lots of them, can amount to grievous bodily harm. Likewise, the known transition of sexually transmitted infections, such as HIV, that can have long-term and serious effects on the victim's health, can amount to GBH. Let's go one more level up. Section 18. Whoever shall unlawfully and maliciously by any means whatsoever wound to cause any grievous bodily harm to any person with intent to do some grievous bodily harm to any person, or with intent to resist or prevent the lawful apprehension or detaining of a person, shall be guilty of a felony. So the difference with Section 20 and Section 18 is, of course, intent. And we discussed that in mens rea when we look at those key terms, and we said how intent hugely raises the severity of a crime. So proving an intent may require showing previous threats, perhaps an offensive weapon's been used such as a zombie knife, or it's even been held that the targeted kicking of a victim's head could all lead towards the higher GBH level charge, Section 18. So that is the list of assaults up to Section 18 and beyond. And beyond this is murder, which we will look at shortly. But there are other assault offences that we should also briefly cover. Now, one such offence is assault with intent to resist arrest, Section 38. Whosoever shall assault any person with intent to resist or prevent the lawful apprehension or detainer of himself or of any other person for any offence shall be guilty of a misdemeanor. Well, it's important to remember that for this offence, the arrest must be lawful. And once that is established, then essentially the defendant only needs to commit a common assault with an intention to resist or prevent an arrest. Another key point to note is that the person being arrested does not need to be guilty of the offence they are being arrested for. A belief in one's own innocence, even if honestly held, will not offer a defence to Section 38. So the law essentially says that if you are being lawfully arrested, even if you are innocent, you cannot resist that arrest. You have to go through with the process. So even if you're innocent, if that arrest is lawful and you assault, then you are guilty of that offence. Right, well, moving on to assault a constable, section 89. Any person who assaults a constable in the execution of their duty, or a person assisting a constable in the execution of their duty, shall be guilty of an offence. Well, think of this as a form of common assault against a constable or someone assisting them. The key here for any question is to make sure that the officer was acting in the execution of their duty. If they were not, the offence is not made out. Interestingly, we find out from the case of Blackburn versus Bowring 1994 that there is no requirement that the defendant knew nor even suspected that the person was in fact a police officer, and you could write a great question from that. So I'll just repeat that again for assault a constable. Blackburn versus Bowring 1994, there is no requirement that the defendant knew nor even suspected that the person was in fact a police officer. Section 89 of the Police Act 1996 deals with obstruct police. Well, there's been a lot of case law around this, as I'm sure you can imagine. Any person who resists or willfully obstructs a constable in the execution of their duty, or a person assisting a constable in the execution of their duty, commits an offence. So we have those words again, in the execution of their duty. Well, obstructing, as you can expect, can occur in many different ways. And one example is the case of DPP versus Glendinning. The respondent was convicted at South Somerset Magistrates Court for obstructing a constable in the execution of his duty by warning other motorists of the presence of a police speed trap on the A303 at Tinkers Hill. I love that name, Tinkers Hill, wonderful. So this just showed us that even flashing and warning other motorists of a police presence doing speed checks counts as obstruct. Well, another example is Ledger versus DPP, which is a far more straightforward one, where we learn that deliberately providing false information to the police can lead you to a charge of obstruct. So quite simply, deliberately lying to the police could lead you to a charge of obstruct, as well as consideration for other offences. So the offence of obstruct is really common sense. But any act must be deliberate, or as the term outlined in the offence, willfully. Someone acting in good faith, giving completely false information, does not commit the offence. So the good person, you're chasing after a burglar, he's just gone around that corner and he points you in the other direction and he says, "Officer, I think they went that way." And in fact, when you review the CCTV after, they went the other way, but actually they were just confused and they gave it to you in good faith. They do not commit it. It has to be a willful act. So simply failing to answer a police officer's questions, unless the person is under a duty to supply information, also does not qualify as obstruct. Now, we could go on about obstruct for a long time, but I've just covered some of the key case law around there and some of those common ones that come up in exams. Well, the next offence is that of threats to kill, section 16, and a real current offence, this one, because there's a lot of discussion in the last couple of years around the offences of threats to kill and threat to life, which I'm sure many of you have been involved in. So threats to kill, a person who without lawful excuse makes to another a threat intending that the other would fear it would be carried out to kill that other or a third person shall be guilty of an offence. So for a threat to kill, we need two things. Again, we simplify it. The making of the threat and an intention that the victim would believe it. So the importance for the offence of threat to kill is the intention of the person making the threat. The threat can be immediate, I'm going to kill you, or in the future, I'm going to kill you tomorrow. However, just passing on a threat on behalf of a third person with no intention from the person passing on the message to make the victim believe it would not suffice. Okay, well, let's very quickly just cover a question on unborn children around threats to kill, as I got asked this the other day from there. And they're fairly common questions, more common than you really would have thought. So again, to simplify, a threat to kill an unborn child is not sufficient if the threat to kill is made before the child is born. If a threat to kill is for when the child has been born, then this would qualify. So that's all you need to remember for threats to kill babies. So finally, the offence of strangulation or suffocation, section 75A, a lengthy and relatively new offence. A person commits an offence if they intentionally strangle another person, here known as B, or does any other act to B that affects B's ability to breathe and constitutes battery of B. So we take strangulation by its dictionary definition, and this covers restricting someone's breathing. But there is a defence you need to be aware of. It is a defence to an offence under this section for A to show that B consented to the strangulation or other act. But subsection 2 does not apply if B suffers serious harm as a result of the strangulation or other act, and A either intended to cause B serious harm or was reckless as to whether B would suffer serious harm. So this defence is from the case of R.V. Brown, 1993. I'm going to cover that a little bit more detail when we look at sadomasochistic harm. These kind of wrapped it, of course, around this. So how does the defence for strangulation work? Well, the victim consents to being strangled, perhaps for or in a sexual act, and harm is no more than transient, and that's going to come from that. If harm is greater than the lowest level, then the defence cannot be used, and it can never be used as a defence for causing serious harm. How do we define serious harm? Well, section 6 does it for us. Serious harm means GBH within the meaning of section 18, wounding within the meaning of that section, or actual bodily harm within the meaning of section 47 of that act. Right, so I briefly mentioned consent to sadomasochistic harm when looking at the strangulation offence, and it's worth elaborating it on here. So, in a nutshell, that sexual gratification from harm. Well, the finding of R.V. Brown was that all assaults which result in more than transient harm will be unlawful unless there is a good reason for allowing a plea of consent. So there is a little bit of subjective element there. But again, one can simply not consent to suffer serious harm for sadomasochistic purposes. Now, the case of R.V. Wilson, 1997, is really interesting because this case is where Wilson branded his initials on his wife's buttocks at her request, and he was convicted of section 47 ABH, but appealed on the basis of consent as a defence. So it was found that as this was a branding similar to tattooing, no offence occurred, and it was deemed as consensual activity in the privacy of the home of a married couple. But this is somewhat of an exception, and any questions around this will be specific around any harm above battery cannot be subject to a consent defence. But we do consent to levels of injury fairly regularly. Even a visit to the dentist or doctor, especially the hygienist, and most commonly, I would say, in playing sport. Interestingly, a person can consent to the risk of serious harm in sports such as boxing, UFC, or rugby. But if you come across any questions around this, they are almost certainly going to be around whether the event is a properly run sporting event. So something like an underground bare knuckle boxing match, you cannot consent. Even if both fighters say we're fine, it's an underground boxing match. You cannot consent to that. So why can you consent for the more serious? Well, think of the World Heavyweight Championship of the world. Think of when Tyson Fury fought Usyk or Anthony Joshua. Think of the medical staff that are present, everything that's put in place. Yes, they're consenting to the risk of serious harm, but because it's properly sporting event, then there are things in place. Same as rugby, same as UFC, same as football. However, playing sport is not a consent to injury per se, not a consent to assault from that, but rather to protect a mistimed tackle that breaks a leg, for example, in football. If, however, the offending player decided to enact revenge against another player by committing a really bad foul with the intention to injure, then they could very much find themselves criminally liable, because they've gone over that point of just playing sport to now committing an assault on the sporting field. And many people have been convicted by taking it too far, and it moves from not a mistimed tackle to seriously injuring someone. So that takes us right up to murder or homicide. So what do we understand by murder? So murder is committed when a person unlawfully kills another human being under the king's peace with malice aforethought. It's a crime of specific intent, meaning the mens rea required for murder is an intention to kill or cause GBH. Well, what do we mean by the phrase another human being? The point you qualify as a human being is when you have been born alive. This is in the eyes of the law, and have an independent existence from your mother. But for exam purposes, the umbilical cord does not need to be cut. You only need to be born from mother. So if you're still attached to the umbilical cord, you qualified still as a human being. Now, murder anywhere in the world. Well, this means that any British citizen who commits a murder anywhere in the world can be tried in England or Wales. So a person from London, they're in Germany, he kills his wife in Berlin in Germany, they can still be tried back in England. And there are 3 special defences which allow for a conviction of manslaughter instead of murder. Now, the first is diminished responsibility. Essentially, that the defendant suffered an abnormality that substantially impaired the defendant's ability to 1, understand the nature of their conduct, 2, to form a rational judgment, 3, to exercise self-control. Now, the abnormality must arise from a recognised medical condition, but examples have included postnatal depression and battered wife syndrome. There's quite a few that have covered from that. The second special defence is that of loss of control, in that the defendant feared serious violence or a justifiable sense of being seriously wronged, and a person of his sex and age with a normal degree of tolerance and self-restraint, and in very similar or the same circumstances, may have acted in a similar way. So lots of things to tick there. And finally, the third is a suicide pact. That's the final special defence, a suicide pact. It shall be manslaughter and not murder for a person acting in pursuance of a suicide pact between him and another to kill the other or be a party to the other being killed by a third person. Once again, let's simplify it. In short, it must be shown that a suicide pact had been made and they all had the intention of dying at the same time that the killing took place. Right, we've covered absolutely loads there from assaults to homicide. So let's have a look at a question. Oh, poor John and Mark. I must change up these names from there. John and Mark are rival builders and see each other in a pub one Friday evening. An argument erupts between the pair which moves outside. John goes to his van, obtains a hammer and attacks Mark, striking him in the head. Mark is admitted to hospital with serious injuries and is in a coma for several weeks. John is arrested and convicted of GBH and receives 14 years imprisonment. Mark requires continuous hospital care and sadly 18 months later after the attack succumbs to his injuries and dies. Can John now be charged with the murder of Mark? A. John cannot be charged with the murder of Mark because he's already been convicted of a GBH and received a sentence in excess of 12 years. B. As John has been convicted of GBH in relation to the assault on Mark, the consent of the Attorney General will be required before a prosecution of murder can be brought. C. John can be charged with murder as the death has occurred within 24 months and Mark has died relating to injuries suffered in the original assault. And D, as John has been convicted of a GBH, the Director of Public Prosecutions must consider the medical evidence relating to the death of Mark and be satisfied that the death was directly related to the original assault and not natural causes or medical negligence. Right, take a few seconds, lots of answers coming on the screen, and we'll go through it. Right, just having a look there. Well, we have got a couple of D's and an A from there, but I think the majority are B from that. And of course, you are correct, as John has been convicted of a GBH, Section 18, in relation to the assault on Mark. The consent of the Attorney General will be required before a prosecution of murder can be brought. Well, to answer this question, we need to understand Section 1 of the Law Reform Act, Year and a Day Rule 1996, which abolished the requirement that the death had to occur within a year and a day of the assault taking place. However, Section 2 of the Law Reform Act outlined that the consent of the Attorney General was required before proceedings for murder could be started, entitled Restriction on Institution of Proceedings for a Fatal Offence. Well, let's have a quick look at the exact wording. Proceedings to which this section apply may only be instituted by or with the consent of the Attorney General. This section applies to proceedings against a person for a fatal offence if the injury alleged to have caused the death was sustained more than 3 years before the death occurred, or the person has previously been convicted of an offence committed in circumstances alleged to be connected with death. Right, well, we've mentioned that word manslaughter a couple of times, but what does it mean? So, how does manslaughter differ from murder? Pardon me? Well, manslaughter differs from murder in that the defendant does cause the death of another, but without the intention to commit GBH or an intent to kill. Manslaughter by unlawful act. The unlawful act must be a criminal offence. As an example, John drives a car dangerously to impress his friend Matthew on the wrong side of the road and driving close to Matthew, intending for an emergency stop at the last minute to scare him. In fact, John slips off the brake and collides with Matthew, killing him outright. John's driven dangerously, that's your unlawful act, killed Matthew. So you can think of this as an offence split into 3 parts. 1. An unlawful act is carried out. 2. The unlawful act is likely to cause bodily harm. And 3. The defendant had the mens rea for the unlawful act. Well, what about manslaughter by gross negligence? Well, gross negligence will always be for a jury to decide, but an example of this, and I'm only going to skim over it from that, perhaps would be a doctor administering a drug to a patient without undertaking significant checks and finding out the patient was actually fatally allergic to the drug they administer and the patient dies. That is gross negligence, and it is it's most commonly seen around the medical world. Right, well, finally, let's have a look at the offence of causing or allowing a child or vulnerable adult to die or suffer serious harm. A person D is guilty of an offence if a child or vulnerable adult dies or suffers serious physical harm as a result of the unlawful act of a person who was a member of the same household and had frequent contact with him. D was such a person at the time of the act. At the time, there was a significant risk of serious physical harm being caused to V by the unlawful act of such a person, and either D was a person whose act caused the death or serious physical harm, or D was or ought to have been aware of the risk mentioned in paragraph C. D failed to take such steps as he could reasonably have been expected to take to protect V from the risk, and the act occurred in circumstances of the kind that D foresaw or ought to have foreseen. Let's break it down. The child or vulnerable person suffers serious harm or dies as a result of the unlawful act by the person. That person was a member of the same household as the victim or had frequent contact with them and was such a person at the time of the act. And at the time, there was significant risk of serious physical harm to the vulnerable person, and either they caused the death or serious physical harm or ought to have been aware of the risk or failed to take steps to protect the vulnerable person, or the act should have been foreseen. Now, any exam question is usually around the household element. Now, always remember that they commit the offence if they were of the same household as the victim, when they died or suffered harm, or they visited so often that it was reasonable to regard them as a member of the same household. So that covers our section on assaults and murder. We've covered lots and lots there. We have to move on because we've only got an hour from that. So let's move on to public order offences and injunctions. So public order. Well, this has become a far more relevant area the last few years, especially after the London riots of 2011. And it's quite an interesting area to study. I'm sure you all have an excellent grasp of it. So let's start with a question looking at violent disorder. I'm just going to rest my voice for that. Have a sip of coffee, so I'm going to let you read this. Have 90 seconds. Best of luck. You'll do absolutely fantastically as always. Right, we're just coming up to 90 seconds there now. Lots of B's, few C's, couple of D's in there as well. Well, the answer is B. Mark can still be convicted of the offence if it can be shown on CCTV that there were 3 or more people using or threatening unlawful violence. And this is violent disorder under Section 2.1 of the Public Order Act 1986. So let's start by reminding ourselves then of the wording. 1, where 3 or more persons who are present together use or threaten unlawful violence, and the conduct of them taken together is such as would cause a person of reasonable firmness present at the scene to fear for his personal safety, each of the persons using or threatening unlawful violence is guilty of violent disorder. It's immaterial whether or not the 3 or more use or threaten unlawful violence simultaneously. No person of reasonable firmness needs actually be or be likely to be present at the scene, and violent disorder may be committed in private as well as in public places. So the question here was whether Mark can still be convicted of violent disorder even though Ralph and Tim have been acquitted. The answer is yes. Mark can still be convicted if it can be proved that there were 3 or more persons using or threatening violence. Well, in our example, multiple people are seen on CCTV acting aggressively. So if it's determined that Mark and 2 unknown males are the ones committing violent disorder, even though they're unknown, the acquittal of Ralph and Tim will not stop Mark being convicted. Right, well, let's have a look at the most serious of public offences now, that of riot. So riot's an interesting offence, as the majority of the offence is spelt out in the definition, where 12 or more persons who are present together use or threaten unlawful violence for a common purpose, and the conduct of them taken together is such as would cause a person of reasonable firmness present at the scene to fear for his personal safety. Each of the persons using unlawful violence for the common purpose is guilty of riot. 2, it's immaterial whether or not the 12 or more use or threaten unlawful violence simultaneously. 3, the common purpose may be inferred from conduct. 4, no person of reasonable firmness need actually be or likely to be present at the scene, and riot may be committed in private as well as in public places. So what else do we need to know about the offence of riot? Well, if you're planning to charge someone with riot, then you'll need the consent from the DPP. There's also that line common purpose, which has led to some confusion. What do we mean by this? Well, it means that all persons must be acting for a similar cause or purpose, but it doesn't mean it has to be a pre-prepared plan. So different groups of people trying to force their way into a football final, for example, to watch it, could be a common purpose, even if there's different groups around. They all have the common purpose of trying to get into that football final if 12 or more persons are present and using unlawful violence. Well, let's go through. What about some other public order offences? Let's have a look at affray. Well, I've put 4 public order offences on the screen, and we're going to start with affray. A person is guilty of affray if he uses or threatens unlawful violence towards another, and his conduct is such as would cause a person of reasonable firmness present at the scene to fear for his personal safety. So let's look at those key points. When it is 2 or more persons using or threatening violence, then their conduct together must be considered. The threat cannot be made by words alone. A person of reasonable firmness need not be present, although for a threat of violence it must be towards a person present at the scene, and affray can be committed in private as well as public places. Moving on to section 4, dealing with the fear or provocation of violence. A person is guilty of an offence if he uses towards another person threatening, abusive or insulting words or behaviour, or distributes or displays to another person any writing, sign or other visible representation which is threatening, abusive or insulting, with intent to cause that person to believe that immediate unlawful violence will be used against him or another by any person, or to provoke the immediate use of unlawful violence by that person or another, or whereby that person is likely to believe that such violence will be used, or it is likely that such violence will be provoked. Well, this is an offence based around the intention of the offender, that the victim would believe the threat. The victim does not actually have to believe it for the offence to be complete. So it's all about the offender's intention that the victim will believe it. The victim doesn't actually need to believe it for it to be complete. But what about a defence or the defence? An offence under this section may be committed in a public or private place, except that no offence is committed where the words or behaviour are used, or the writing, sign or other visible representation is distributed or displayed by a person inside a dwelling, and the other person is also inside that or another dwelling. So no offence is committed where the words and behaviour used or the visible representation, say a sign, is used or displayed by a person in a dwelling and the other person, the victim, is also inside that or another dwelling. Well, this essentially means it cannot be committed by persons inside a dwelling, a person's home or living accommodation, but it can be committed in a garden to a neighbouring garden. So it cannot be committed from one dwelling to another if no one else be seen, but it can be committed in the garden of a dwelling. So that was a case where racist abuse was shouted from a neighbouring garden to another neighbouring garden in the case of DPB versus Distil 2017. Section 4A deals with intentional harassment, alarm and distress, which to summarise is with intent to cause a person harassment, alarm or distress, uses threatening, abuse or insulting words or behaviour, including disorderly behaviour, or displays any visible representation that causes such. Again, it's the offender's intention to cause a person to suffer a harassment, alarm or distress that's important. The same defence applies in relation to the dwelling, and police officers can of course be victims of this offence. And finally, section 5, public order. A person who uses threatening, abusive words or behaviour, including disorderly behaviour, or displays any visible representation within the hearing or sight of a person likely to be caused harassment, alarm or distress, commits an offence. So for section 5, it must be shown that there was someone present to witness the behaviour, but their evidence is not necessarily required to secure a conviction. And that question has come up before. So I'll repeat that. For section 5, it must be shown there was someone present to witness the behaviour, but their evidence is not necessarily required to secure a conviction. The same defence applies. We spoke to the dwelling, but there is a second defence that falls to the defendant in that they need to show that they believed that they had no reason to believe that there was anyone that could hear or see their behaviour. Right, but that's enough from me. We've gone through loads so far. Let's have a look at questions, which leads us into injunctions. So William is 16 years old and the court are considering an injunction owing to William being involved in gang-related violence. It's said that William has been enforcing debts owed to the gang with several other members. Which of the following is correct with what the court must satisfy themselves with to issue an injunction under section 34 of the Policing and Crime Act 2009? A, the court must satisfy themselves on the balance of probability that William has engaged in or encouraged or assisted gang-related violence. B, the court must satisfy themselves that William has engaged in gang-related violence and that this violence has been recorded by the police. The court must satisfy themselves that William has been arrested for gang-related activities in which violence was used or threatened. Or D, the court must satisfy themselves that William has been convicted at youth court of an offence where he has engaged in or encouraged or assisted gang-related violence. Oh, E and B are going for A, and Stuart D for A, and everyone else going for A. You're all quite brilliant, aren't you? You really need to get this exam pulled forward. It's going to be an absolute record of exceptional marks. You're doing fantastic. This revision's paying off. Absolutely, really, really good. Take your time. Anyone else, have a read of the question, get your answer up, but lots and lots of A's. Absolutely brilliant. A wicked part of me wants to say D now and be absolutely horrible, but then I'd be absolutely vilified. Of course it is. You are perfectly correct. The answer is A. The court must satisfy themselves on the balance of probability that William has engaged in or encouraged or assisted gang-related violence. How good are you? Absolutely fantastic. There are a number of preventative and protective measures available to stem antisocial and criminal behaviour. So here we have a court injunction under Section 34 of the Policing and Crime Act 2009. And an injunction under this section can be granted against a person 14 years or over if the court is satisfied on the balance of probabilities that they have been part of a gang-related violence or drug-dealing activity and that an injunction is necessary to prevent engaging in such gang-related behaviour. The injunction can prohibit the person from doing anything outlined in it. But let's have a closer look at the term gang-related. Well, gang-related involves activities linked to a group of at least 3 people and that have one or more characteristics to be identified by others as a gang. For the drug dealing element, this is linked to production, supply, importation or exportation of a controlled drug or psychoactive substance. And the court may attach a power of arrest, and the suspect can be arrested if the officer suspects them to be in breach of Section 34 injunction. If arrested, the officer must inform the person who applied for the injunction of the arrest, and they must be brought before a judge within 24 hours of the arrest. Let me repeat that because that does come up in questions. So when it comes to the court may attach a power of arrest, and the suspect can be arrested if the officer suspects them to be in breach of the Section 34 injunction, and if arrested, the officer must inform the person who applied for the injunction of the arrest and must be brought before a judge within 24 hours of the arrest. So what about an application for a civil injunction, which is made to a youth court when the person is under 18 years of age, and in all other cases, the High Court or the County Court? Well, if a joint application is being made and one person is under 18 and one over, then it can be heard in the youth court if it's believed it's in the interests of justice. So, an injunction under the Antisocial Behaviour and Crime Policing Act 2014 may be granted to a person aged 10 years or over if they are satisfied on the balance of property that the respondent has engaged or threatens to engage in antisocial behaviour. And that is just inconvenient to grant such an injunction for preventing such behaviour. Prohibitions can be set and specify the period for which it has effect, which for under 18s is a maximum of 12 months. The court must consider any impact on school or work attendance. Antisocial behaviour is considered as conduct that has caused or is likely to have caused harassment, alarm or distress to any person or conduct which is a nuisance or annoyance or capable of causing such to any person. And talking of antisocial behaviour, let's move on from public order injunctions to our final section, misuse of drugs. Right, well, this is a huge section, and I think I've got 8.5 minutes left, but we might run slightly over, but we're going to cover as much as we can. Now we're going to cover all of it from there. Even if we run a couple of minutes over, it's not a problem. Right, well, we're going to start by having a look at the concept of possession. We will then look at a number of offences, and we will look at defences. But as normal, let's start with a question. Good luck, everyone. Well, you don't need luck, actually. You're going to get it fantastically right. Nice question, this one. PC Hamilton conducts a warrant at Patrick's home address. During this warrant, PC Hamilton seizes 2 large cannabis plants, which he takes back to the police station and places them in the property office. PC Hamilton decides to keep the plants alive, believing it will be impactful evidence at the trial. PC Hamilton waters and feeds the plants daily, and when he's not on duty, Glenn, the property officer, waters and feeds on his behalf. Agatha is a cleaner at the police station and one weekend is cleaning the property store and sees the cannabis plants. She does not know what they are, but they're looking a little wilted and gives them some water. Considering the offence of cultivation of cannabis, who, if anyone, has committed the offence? A, all three. B, only PC Hamilton and Glenn. Agatha does not, as she's unaware that it's not genus cannabis. C, no one commits the offence as the plants are not being cultivated for the purposes of harvesting evidence. Or D, only Agatha commits the offence as she has no lawful authority to tend to the plants. She does, however, have a defence as she doesn't know that the plants are genus cannabis. So a B, lots of A's, couple of C's. Take a few seconds and we'll have a look. Oh, it's got a few B's and a couple of A's. We'll take it from there. Right, so we got some A's, we got some B's, and someone's left the meeting. I've upped them so much with my question about Agatha and the rest of them. Well, PC Hamilton, Glenn, and Agatha all commit the offence. The offence of cultivation of cannabis is extremely simple. It shall not be lawful for a person to cultivate any plant of the genus cannabis. Cultivation is not defined, but it lends itself to its dictionary meaning, the act of caring or raising. Now, clearly, feeding and watering would fulfill this. Now, poor Agatha. It doesn't matter that she doesn't know it's cannabis, but that is the law. All you have to do is cultivate. But this is where we have real world to exam world. Would you really charge poor Agatha in a real world scenario? No, we wouldn't. Very unlikely we would from there. But for the purposes of the offence, she is guilty. PC Hamilton, we'd have to have a few words with, because he is not allowed to nurture or care for the cannabis plants, no matter how good he wants his quality of evidence at court. So all three commit the offence, but of course, poor old Agatha and poor old Glenn from that. But fantastic, the majority of you got that answer correct from there. So the only thing you got to remember is when it comes to cultivation of cannabis, they just have to cultivate it by watering it or doing something with it, and it just has to be cannabis. They don't need to know it is. Right, okay, we better speed up here. So I've listed the class of some drugs, but I'm not going to go into that there because you're not going to get tested straight out on that. And if you do, then I'm really sorry, but I've never known it before. One area I do want to cover is that of possession because it does cause some confusion. So I firstly want to point out that possession does not mean an offence has been committed. We're only looking at the concept of possession. And I'm going to come into that in more detail shortly. So for possession, 2 points must be proved. I really like my points in this session, don't I? 1, that the person must have custody of the drug, and 2, knowledge that they have possession or custody of the thing. You'll understand why I've used the word the thing. So let's consider a simple example. John holds a packet of cigarettes for his friend Mark. John believes that the packet of cigarettes contains only tobacco, contains only cigarettes. In fact, the packet of cigarettes actually contains several rolled cannabis joints. John is in possession of those drugs. Now, no one is suggesting that John is committing an offence, but John is in possession of the cigarette box known as the thing, and he knows there is something inside that cigarette box. Now, he believes it to be tobacco, but in fact, they're rolled cannabis joints. Therefore, John is in possession of those joints, but it's a possession, not an offence. But if Mark had sneaked that packet of cigarettes containing the joints into John's jacket pocket, and he had a big jacket with big pockets, and he wasn't looking, and John did not know those cigarettes had gone in there, then John is not in possession of the drug as he has no knowledge of possession of the thing. Right, well, let's move on and have a look at some offences around drugs. No, in fact, do you know what? Let's kick off with a question. So DC Ahmed is on plainclothes patrols working on a number of pubs in the town centre after an increase in overdose reports. He is stood at the bar when he's approached by Roger, who says, "Are you looking for some gear, mate? Good prices, got cocaine, heroin or ecstasy?" Roger's not mucking around there, is he? DC Ahmed identifies himself as a police officer and detains Roger. A colleague supports him and they search Roger in the office at the back of the bar. No drugs are found and Roger is arrested for Section 4. The next morning he's being interviewed and says, "I didn't have any drugs to sell and in fact I wouldn't even know how to get any." Can Roger be guilty of an offence of Section 4, supplying a controlled drug, in these circumstances? A, he does not commit the offence as he was not in possession of the drugs. B, does not commit the offence as his offer was not genuine. C, he commits the offence when he makes the offer. It's irrelevant if the offer is genuine. D, Roger commits the offence when he makes the offer if it can be shown there is corroboration that he is involved in drug dealing. Oh, just look at the screen. There we are. And there's a load of C's coming up there. Fantastic. Really good. But the way you're answering these questions, in all fairness, and these are exam style questions from there and adapting the knowledge, is really good, and it's really impressive to see. Well done, everyone that is that's answering these questions. So the answer is, of course, C. Roger commits the offence when he makes the offer. It's irrelevant. Under Section 4.3 of the Misuse of Drugs Act 1971, a person commits an offence if they supply or offer to supply a controlled drug to another, whether the accused had a controlled drug in their possession or had access to a controlled drug, or whether the substance in their possession was a controlled drug at all, is immaterial. Whether the accused can carry out the offer is also irrelevant. The offence is complete upon the making of an offer to supply, regardless of whether the offer is genuine or not. And once an offer is made, it cannot be withdrawn. Now, interestingly, an offer can be made by words or conduct. So how can you make it by conduct? Well, imagine mimicking the sniffing of cocaine by holding one of the nostrils and nod to the head. Well, this could all qualify, albeit it'll be slightly more difficult to prove, but it still could be seen as an offer. Now, our circumstances come from the case of R.V. Cray, 1998, for an easy one to remember, where the suspect was targeted by an undercover police operation where he discussed supplying cocaine during a car journey. Cray argued that he was entrapped and sought to exclude police evidence. However, it was found that regardless of whether it's a police operation or not, an offer to supply is sufficient. So, as you'll be aware, there are a number of offences under the Misuse of Drugs Act. So let's start right at the beginning with possession of a controlled drug. Right, we've got 1 minute. We might go 5 minutes over here. No problem. Anyone that needs to go, please. I won't be offended. I understand. Sort of free time is very, very precious. So please don't worry. Now we've briefly looked at the concept of possession. So this is the offence where someone is in control of a drug and has knowledge of that drug. In simplest terms, I have a small bag of herbal cannabis in my pocket. I know it's cannabis and I'm carrying it. I am committing possession and committing an offence. Right, very simple. But there are two key defences when it comes to the possession of drugs. Now, the first I call the mum and dad defence. Mum is tidying up her son Tommy's room. She finds on his desk a small bag of herbal cannabis. Mum is furious. Mum can, as soon as practicable, destroy the drug, flush it down the toilet, or take it to someone that can legally possess it, such as a police officer. So to quote the defence under 4A, knowing or suspecting it to be a controlled drug, took possession of it for the purpose of preventing another from committing or continuing to commit an offence in connection with that drug, as soon as possible after taking possession. Remember that, as soon as possible after taking possession, they took all steps as were reasonably open to them to destroy the drug or to deliver it to a person lawfully entitled to possess it. So two things there: as soon as possible destroy, or to deliver it to a person lawfully entitled. What about the wanderer's defence? Well, Keith is walking down the road when his eye catches something on a wall. He looks closely and there's a bag of herbal cannabis. Keith doesn't know who it belongs to. He has one defence if he takes the herbal cannabis to someone that can legally possess it as soon as possible. Let's break it down. Knowing or suspecting it to be a controlled drug, took possession of it for the purpose of delivering it to a person lawfully entitled to possess it, and this occurs as soon as possible after taking possession of the drug, and they took all steps reasonable open to him to deliver it to the person that can legally take it. So in this defence, the wanderer's defence, destruction is not an option. If it's found, it's got to be taken to somebody who can legally possess it. Well, an offence you should be aware of and have dealt with on a number of occasions is possession with intent to supply, or PWITS. It's an offence for a person to have a controlled drug in his possession, whether lawfully or not, with intent to supply it to another. You are in possession of drugs and you intend to supply them to another. So lawfully or not, what do we mean by this? Well, if a police officer sees drugs lawfully and they're in their possession, but decides to make some money on the side and forms an intention to supply, well, you commit the offence. Now remember, drug paraphernalia will be relevant evidence to assist a charge of PWITS, but will not be sufficient if it's the sole evidence. And likewise, as we know from the case of R.V. Smith, Ivor 1995, outlined for us that unexplained wealth can be supporting evidence of earnings for an intention to supply. Right, well, what about the offence of prohibition of supply of articles for administering or preparing controlled drugs? We'll rattle through that really quickly. Well, this essentially is about a person who supplies or offers to supply any article which may be used or adapted to be used with somebody else for administration by any person of a controlled drug to himself or another, believing it will be used as such. In simple terms, the supply of drug kits. Any question around this, or the majority of questions you're going to get around this, is to do with part 2. It's not an offence under this subsection 1 above to supply or offer to supply a hypodermic syringe or any part of one. So when it comes to a question on supply of articles, they're very common to see if it is a hypodermic syringe. That is not covered. Production of a controlled drug is again a very simple offence whereby someone is involved in the production or concerned in the production of a controlled drug. Now, this needn't be Breaking Bad style of cooking up vast quantities of meth. Production is a wide-ranging term and includes converting one drug to another, cocaine to crack cocaine, or even stripping and harvesting a cannabis plant. Now, being concerned in the production, again, is simply being involved in the production of the drug in question. So stirring a big vat of liquid meth would, of course, suffice. And finally, poor old Agatha, who we covered before, who watered the cannabis plant. You just need to remember what we said about cultivation. Right, going on to our next. Right, we looked at the mum and dad defence, we looked at the wanderer's defence, but there's also a general defence under Section 28, and it's in 3 parts. Important to be just cover this quickly. Coming to the end, you've done fantastically, everyone. Okay, this defence is available for the majority of drug offences, but not those charged with conspiracy. So under a general defence under 28 cannot be used for conspiracy. So there's 3 parts. The first is a lack of knowledge by the defendant of some alleged facts. Let's bring John back into this. So for this, the defendant does not have reason to suspect the existence of a fact that is key to the case. So John is asked by his brother Steve to drop off a video game to his friend Rob. John is stopped by the police, and when they open the video game box, they find it contains several wraps of cocaine. John was unaware of this and has a defence, a lack of knowledge that the video game case contained drugs. The second element is a general lack of knowledge by the defendant in relation to the drug in question. The defendant does not suspect the substance is a controlled drug, so Mary picks up what she believes to be powdered paracetamol in her son's room, but she's actually holding a bag of cocaine. Mary has defence. And finally, and a similar one here, a conditional belief held about the drug in question. Peter is being prescribed methadone, but the chemist, completely by mistake, accidentally gives buprenorphine by mistake. Peter takes the buprenorphine, believing it to be methadone, is stopped outside by police and says, this is methadone that I can have, but in fact, it's not, it's a different drug. So really, again, common sense stuff, but important 3 elements under Section 28. Right, so a quick look at police powers under 23, and then we'll conclude with a question. So Section 23 of the Misuse of Drugs Act is the key power available to police when it comes to the war on drugs. If you suspect someone is in possession of a controlled drug, then they have a power to search them, any vehicle or vessel they suspect it could be in, and seize anything found which appears to be evidence. A warrant can be obtained under Section 23. I'm sure many of you have got them many times, authorising the search of a premise only. Then unless another power exists, then it does not give them permission to search any person on that premise. But the majority of warrants will cover this. And a drugs warrant under Section 23 lasts for a period of 1 month. Right, let's have a look at one last question, and I'm going to get you back to your homes. You've been absolutely fantastic. Right, a new drug has been discovered on the street called phosphos. This has been found in possession of a number of users and is highly addictive. Tests on the drug show it to be a synthetic and it's believed to be developed in the Middle East. Phosphos leads to the users suffering serious fatigue and migraines. A temporary class order is being considered. Which of the following statements is correct? A. Any temporary order made will come into effect within 28 days of the application being made and last up to 18 months. If a similar type of drug is already controlled under the Act as a Class B or C, a temporary class order will be reclassified as A with immediate effect. C, once nominated, the temporary class order will come into immediate effect and will last up to 12 months. And D, for a temporary class order, it only needs to be shown that the drug is likely to be misused. Well, take as long as you guys need. We'll go through that. Oh, lots of C's coming up here. Oh, wonderful, absolutely wonderful. The exam, you should all sit it tomorrow. You're that good. It's just going to be a new record of exceptional marks. You're all going to make wonderful investigators, detectives, sergeants, inspectors. You're absolutely brilliant. Really, mate, it's fantastic. Of course, it's C. The Home Secretary has the power to make any drug nominated subject to temporary control, which means an order made will come into immediate effect and will last up to 12 months. Parliament will then be required to agree within 40 days sitting of the order being made. So temporary class drug orders can be made if the following two conditions are met. One, the drug is not already controlled under the Act as a Class A, B or C drug. And two, the Advisory Council on the Misuse of Drugs have been consulted and determined that the order should be made, or the Home Secretary has received a recommendation from the Advisory Council that the order should be made on the basis that it appears to the Home Secretary that A, the drug is being or likely to be misused, and B, the misuse is having or is capable of having harmful effects. So it's important to remember, though, that simple possession of a temporary controlled drug is not an offence under the Misuse of Drugs Act, but officers do have the power to search and detain a person or vehicle if there are reasonable grounds to suspect that they have a temporary class drug on them, seize, detain and dispose of this suspected temporary drug, or arrest or charge a person who intentionally obstructs an officer in the exercise of their powers. You are fantastic. You're brilliant. We've covered 5 areas: assaults, homicide, public order, injunction, the misuse of drugs. I'm out of breath. That's not bad going for an hour. Thank you all for staying on for an extra 9 minutes. So if you've enjoyed that and haven't signed up, think about signing up. It's not too late. The NIE exam is the 4th of March, 3 weeks away, and you can pass it if you focus now. And we've got that coupon on there. The discount takes it down to around £75. Likewise, those still in the sergeants and inspectors, that discount also works for you. So exactly the same on PR. We look at offences, key points, break it down and make it easy to understand. You love questions, lots of questions and a huge amount with full explanations on there. You can see the explanations from there. We also have Crammer courses on there. I think it's 8 full 80 question NIE exams, 6 inspector and sergeant exams, plenty to get you through. So please have a look. Always go on there, www.policerevision.com. Right, what have we got left, guys? We've moved off. I've done the sales part now from there. Okay, so we've got 2. I haven't changed it from the last session. Look, I said I put it in so badly there. Look, I do all the nice things. Okay, it's Monday the 24th of February, 6 p.m. till 7 p.m. Crammer sexual offences. Then 2 days later, twice in a week, look at that, Monday and Wednesday night. From that, we have property offences on Crammers. Okay, so we're going to get those 2 done on the 24th. So there's nothing next week. Then we've got 2 the week after. And if you lot pester me from there, then there's any subjects that you want covered, let me know, email me. Here we are, info@policerevision.com. It comes straight to me, James, and I will have a look at that. Any topics you're not short of. What a great session we had today. Really, really enjoyable from that. Absolutely fantastic. You're brilliant at questions. Keep up the revision. Keep up the hard work. You're almost there. You have to sit the exam once and you are going to ace it. Guys, see you in a couple of weeks. Drop me a line. Any questions, any areas. You know I'm passionate about this, and I will see you in 2 weeks. Bye, everyone.